Hello, for today's tips and updates, 13th of March 2025, let's look at understanding the role and needs of the attorney, the advocate, and the judge. Yesterday we did part one, which was a little bit of an introduction to the topic, and then the attorney. And today let's have a look at the advocate and the judge. And start with the advocate. Now, the role of the advocate is to prepare and run a high court trial. We've had a look at the role of the attorney. You can, if you want to compare the two roles, the advocate's needs are effectively to win the case, or not every case can be won, so the advocate at least wants to present that case persuasively and present it therefore well in accordance with what the advocate needs to deliver. And in order to do that, the advocate needs to understand the expert witness's opinion and the reasons for the opinion. Very important, because if the advocate understands the opinion and the reasons for the opinion thoroughly, then the advocate understands the expert's argument and understands the expert's case theory, and then is able to use that particular piece of information to build his or her case. And then also the advocate needs to place the expert's opinion within the context of the whole case. So the advocate needs to build that case and build a case with reference to the legal position, the law, with the expert evidence, and then to the facts which are being dealt with, and put all of that together in a cohesive and coherent argument. Key tip for when dealing with an advocate: explain to the advocate so that he or she can clearly understand your logical reasoning, your case theory, and can then prepare to lead witnesses, cross-examine witnesses, and present argument, which is the essence of what happens in a trial. And by understanding your case theory or your logical reasoning, the advocate is then going to be well equipped to use that in all the different ways an advocate needs to use that information. Let's move on to now the most important role player, which is the judge. The judge is the person who obviously decides the case. The judge doesn't have unfettered powers, but has considerable power to decide the case in the direction which he or she sees it should be. Their needs are that they need to write a judgment under time pressure. Don't underestimate the amount of pressure which the judge is under from a workload point of view. Judges aren't just dealing with your matter. You know, I've seen from the advocate's or the expert witness's perspective, we've got a lot of time to prepare a single case and pay a lot of attention to it. Judges don't have that luxury, very, very seldom. So normally they've got a lot of matters on their desk, a lot of cases they're dealing with simultaneously. Your case is just one of them. They need to get it right, as we'll see in a moment, but they also need to get it right quite quickly. So they need to write a judgment under time pressure, and that judgment has got to be correct, because it could well be scrutinized by a higher court and will certainly be scrutinized by the advocates that appear before the judge. The judge needs to be able to assess the expert's process of logical reasoning. So similar to the advocate and the attorney, but here it's a bit different. The judge will really scrutinize very closely every detail of your reasoning, and must also be able to understand complex matters clearly. This is very important. You want to be able to, as an expert, take matters which seem complicated and distill them down to their essence. And really, the important thing, in order to do that, you need to understand clearly what you're trying to say before you can communicate to any other person what your particular point is that you're trying to make. And then I'd say the key tip for a judge, I would say, be helpful. Remember, at the end of the day, the judge is a lay person in respect of your discipline. You wouldn't be able to be testifying as an expert if the judge had the information which you have. When we look at the definition of an expert and the basis on which expert evidence is admissible, we'll deal with those concepts a bit more fully. But you must be able to summarize your process of reasoning case theory quickly. So a quick summary. What is your position? What is your opinion? And simply, so break it down, not jargon, not fancy technical talk, quick, simple explanation of what your position is, and then be able to back every part of your summary up with detail. There's that balance between the essence and then the detail. You have to be able to see the bigger picture and the detail at the same time, and explain that in a way that the judge will understand. Thank you. That brings us to an end of this particular video. As ever, if you like the information in the video and you'd like more information, our Expert Witness Guide is designed specifically to assist expert witnesses to perform better in their written and oral work. Thank you. See you in the next video.